Hello and welcome to the Victoria Law Foundation Headstart program for Unit 1 of Legal Studies. My name is Jane Patrick and I'm talking to you about the legal system in Victoria because I've had some experience of the legal system. I was a magistrate in the Magistrates Court for 8 years and then I was a judge in the County Court of Victoria for 10 years. So that's my background and why I'm talking to you about the legal system in Victoria. In Legal Studies Unit 1, you will be studying the legal system, as I've said, that operates in Victoria. That means you'll be looking at how laws are made in Parliament and the courts and the role that the legal system plays in our society. Now, most of the time we go about our daily lives without thinking about the law, but the laws apply to many of our activities. For example, if you're driving or you're shopping or you're working, if you own a dog, or if you go on a train, there are laws that apply to all of those activities. Unless something goes wrong, you don't really know about it, you don't worry about it. But the reality is that law operates in so many areas of our everyday life. Now, laws are made for various purposes. They're made to protect the rights of individuals and to prevent harm being caused by individuals to others. Laws can be made to protect broader social objectives, such as the protection of the environment. So there are laws that prevent the discharge of hazardous waste, for example, and that's to protect the environment. Laws are also made to provide a framework of rules within which all of the citizens in a country or in a state of Victoria can operate, knowing what the rules are and knowing how they apply. So people can work together cooperatively. I mean, you can imagine what driving would be like if there were no road rules. Absolute chaos. And I think probably we are lucky that it's not as chaotic here as it is in some places in the world. But nevertheless, that's what the road rules do. They mean that we can all drive around the road, sharing the roads and working cooperatively together. So there are different rules, different views, on whether we have too many laws or not enough laws, or whether any particular law is the right law. No legal system that I'm aware of is perfect, but my personal view is that the legal system of the type that we have in Victoria is one of the most amazing and greatest of human inventions. Laws don't exist out there anywhere. There is no legal system that comes in from somewhere out of space or something. It's a human invention. And it's a human invention in order to make us be able to work together and live together in relative harmony. If we didn't have laws to protect people's rights or to protect, to set out people's responsibilities or to provide remedies or consequences if things go wrong and to sort out disputes, what would happen is that we would risk having a society that was a lot more chaotic and where there would be much more use of baseball bats in order to enforce your rights or protect yourself against other people. So you will be looking at how laws work to achieve a degree of social cohesion, that's so people can work together cooperatively and in a society where people understand what their rights and responsibilities are. Now, in our democratic system, citizens might disagree about specific laws, but everybody seems to generally agree that we should have a legal system that applies to everybody. Now, in order to keep that agreement going, it's very important that there be respect for the legal system and that the laws and the legal system, including the courts, embody the principles of justice. And you will be looking at the principles of justice in your course. Some of you may have seen the picture of Justice, Lady Justice. This symbol of a lady with a sword, scales and a blindfold is commonly used as a symbol for justice to demonstrate the principles of justice that operate in Victoria. The original idea came from a Greek or Roman goddess. You will be looking, I imagine, at the history of how this figure came to be, but the sword represents sort of power, the power of justice and reason. The blindfold means that the law operates without passion or prejudice and on the facts. The scales are there to show that facts are balanced and that decisions are made according to a balancing of the facts. And what that balance might be, we'll discuss a bit later. The picture that you're seeing there is of the design that was done for the County Court of Victoria building, where I worked for many years. And you can see that there is the right hand is how the Justicia, as she is called, is displayed on the actual face of the building of the County Court. All right, so that's Lady Justice or Justicia. She embodies, and that image embodies, the three principles of justice that operate in our justice system of fairness, equality, and access. And when you are studying legal studies, you will be looking at how successfully or not these three principles of justice are played out and actually operate in our legal system. Fairness is a fairly obvious one. Nobody should be treated unfairly. Decisions should be consistent and operate fairly between people. I'll give you an example that operated in the work that I did, which is in sentencing. So in sentencing, one of the principles that judges pay attention to is an attempt to achieve consistency. That's difficult because all crimes are different, all criminals are different, and all victims are different, and the consequences are different. But even within those constraints, it's important that as far as possible, people are treated consistently in terms of the punishment or consequences, because that's the way people are treated fairly. So that's fairness. That's fairness in operation in the criminal law. In courts, all individuals are treated with respect and dignity and should be treated fairly and given a fair hearing. So equality plays out there too. Like I said, all laws are made on the basis that they apply to all people equally, and all people are equal before the law. Now, sometimes that doesn't seem like it's playing out well, because sometimes you get the impression that if someone's rich and got a top lawyer, then they might be able to use the legal system in a way that someone who doesn't have much money can't do. That's something that you might be going to look at in your legal studies course. Access to justice is important. Does everybody have access to justice? Sometimes people really don't have access to justice because they can't afford lawyers, or because they're not eligible for legal aid, for example. So those are things that you will be looking at in the course of your legal studies course. Now, who makes the laws for Victoria? These laws that operate, hopefully with fairness, equality, and access, who makes them? There are two ways in which laws can be made. Laws can be made by the courts, and they can be made by Parliament. Now, the way that laws are made by courts are that courts make decisions about what the law and the principles ought to be. And if that decision is made by a superior court, by a top level court, then the courts lower down have to follow that precedent and follow that decision. So in the legal system that developed in England, and which we've inherited in Australia and indeed in Scotland and Ireland, precedent meant that the courts developed laws. And for example, the courts developed the law of negligence in a landmark case called Donoghue and Stevenson, which was decided in 1932. And it's a case about a lady who went into a shop and wanted a drink, wanted a combination of ice cream and ginger beer. It was called a Scottish something or other, which I've now forgotten, but that's what she wanted. The waiter brought out a Stevenson's bottle. There you can see the Stevenson's bottle, and poured out the ginger beer over her ice cream. And lo and behold, there was a snail. You can see the snail there on top of the bottle. I think that's I'm not sure if that's the same snail, but there is a snail on top of the bottle. That just she took the Stevenson company who made the ginger beer and put it in the bottle to court. And ultimately she won because the judge, Lord Atkin, said that the principle was you must take reasonable care to avoid acts or omissions which you can reasonably foresee what would be likely to injure your neighbour. So that is the basic fundamental principle of negligence cases, where one person sues another person or a company because they say that that person, the second person, has been negligent towards them and they have suffered harm. That was not developed by Parliament or anything else. It was a development of the common law by the courts. And those principles and that principle still applies today, and it applies here. There are other areas in crime where common law still persists. For example, with murder, the Crimes Act in Victoria sets out what the penalty for murder is, but it doesn't tell you what murder is. So the crime of murder, which is when one person causes the death of another person with the intention of causing their death or grievous bodily harm and without lawful excuse, then that's murder. All of those things that I just said are in the common law, they're not in a statute. I've explained to you before about precedent and the court hierarchy when I said when a higher up court makes a decision, then the lower down courts have to follow that decision. So the court hierarchy in Victoria is shown in the next slide. So the bottom court is the Magistrates Court, then there's the County Court, then there's the Supreme Court, the Supreme Court Court of Appeal, and then the High Court of Australia. So the way this works is that the courts have to follow the decisions of the courts above them. Really, in practice, it is the Supreme Court, the Supreme Court of Appeal, and the High Court of Australia which makes law for Victoria. The Magistrates Court and the County Court follow the decisions of the Supreme Court, the Supreme Court Court of Appeal and the High Court of Australia. And they are required to follow them. It's only the higher courts that can depart from precedent, and there are also rules about all of that. So the highest court in Australia for all of Australia is the High Court of Australia. The highest Victorian court is the Supreme Court Court of Appeal. If you want to go further from the Supreme Court Court of Appeal, then you must appeal to the High Court of Australia. So from the Magistrates Court, you appeal to the County Court. County Court, you appeal to the Supreme Court Court of Appeal. And if you want to appeal from there, you go to the High Court of Australia. The Supreme Court of Victoria has its own jurisdiction, and their appeals go to the Supreme Court Court of Appeal. So that's how precedent works. And that's how it means that if a decision's made which changes the law, the common law, or interprets a statute, for example, a piece of legislation passed by Parliament, then the lower courts have to go along with that interpretation or that application of the law. So what's this legislation and what parliaments make law for Victoria? There are two parliaments that make law for Victoria. That's the Commonwealth Parliament, Commonwealth Parliament and the Victorian Parliament. The Commonwealth Parliament has the power to make laws for certain areas of activity throughout Australia. And if they make those laws, then they apply in Victoria. The Victorian Parliament has the power to make specific laws for specific areas of activity in Victoria, and such as crime, health. There are a number of other, lots and lots of areas where Victoria has the power to make all the decisions for everyday life. The Victorian Parliament passes acts such as the Crimes Act 1958. This is the first part of that act, just to show you an act. When it's passed, if it's printed in printed version, it looks like a small book. Sometimes it looks like a large book, but it looks like a book. Nowadays, everybody accesses them online, so you don't see it in that form very often. But if you ask for a hard copy of an act, it will come in what looks like a book. And in Victoria, printers print them with a green cover. The Crimes Act authorised version number 294, there you are, that was started being made in 1958, but it's been amended many, many, many times since. So this authorised version incorporates amendments up to the 1st of March 2021. There's a big index. You can see that starts from page 1. And the Crimes Act 1958 actually goes on for about 765 pages. So you can imagine it's a big document. And it keeps changing all the time, which makes life a bit harder for magistrates and judges. Most of the work that goes on in the courts involves applying the relevant law to the case before the court and making a decision according to law after a fair hearing. There are two types of areas that the courts work in. There's the area of civil law and criminal law. So civil law is where, like negligence, where one person or one company sues another person or another company, and because harm has been caused to them of some sort and they want a remedy. Usually the remedies are damages, that is money to pay compensation for the harm that's been caused, but sometimes there are other remedies available. So that's the civil law. Criminal law is where the state, on behalf of the community, takes action, prosecution action, against an individual who is accused of having committed a crime or offence. The courts in Victoria then have criminal and civil jurisdictions. I've shown you a slide of the court hierarchy, and I want to show you a couple of slides which show to you what the difference in the workload of the courts is and the number of cases that they deal with. I've taken these slides from the statistics available from 2018 and 2019 because they are pre-pandemic basically, and will be a reflection of what the normal situation is. And really they're just to give you an indication of the scale of the different types of work of the courts. So in crime, the Magistrates Court does about 152,000 cases. You can see that there. The County Court does a bit over 5,000, which includes nearly 3,000 appeals. Those appeals are from the Magistrates Court. So if you don't like your conviction or sentence in the Magistrates Court, you can appeal to the County Court. At the moment, you can appeal as of right. You don't have to give any reason. And the County Court deals with the matter as if it's a new hearing, as if the Magistrates Court hearing never happened. That was supposed to change. There's new legislation on the books from Parliament saying that you have a different process whereby the County Court has to see if there's a reason why they should hear the appeal, and you have to get leave to appeal in a different way than you do now, so you don't have an appeal as of right. And the County Court has to look at the reasons of the Magistrates Court and the evidence presented in the Magistrates Court. That legislation was put on hold because of the pandemic, and it was thought that implementing it would mean that there would be more time taken in the Magistrates Court and indeed in the County Court in dealing with appeals. At the moment, appeals are dealt with fairly quickly. So in the County Court, those cases which are not appeals, by and large, are jury trials and sentencing hearings for people who plead guilty. Supreme Court Trial Division has a jurisdiction, about 100 cases, and their jurisdiction, they deal with cases which are more serious than the ones in the County Court. For example, the County Court can't deal with murder, can't deal with manslaughter, can't deal with treason, and there are a few other things. So they all have to go to the Supreme Court, and also the Supreme Court may be the starting point for some very serious cases, such as big drug importations or drug trafficking cases, or very important and more serious cases where the Office of Public Prosecutions thinks that it ought to be dealt with in the Supreme Court rather than starting off in the County Court. The Magistrates Court has jurisdictional limits. You can only go to the Magistrates Court for certain offences and if you're looking for a certain amount of money. Supreme Court Court of Appeal deals with appeals from the County Court and also from the Supreme Court Trial Division. To go to the Supreme Court Court of Appeal and successfully appeal against a decision of the County Court or the Supreme Court Trial Division, the accused or the prosecution going to the Supreme Court of Appeal have to demonstrate that there has been some error of law. So that's not a right. You have to show that there's been an error of law in the proceedings, and then the appeal can be heard. Thank you. Then civil is the other area. You can see again, there's a difference in the volume of cases. The Magistrates Court again is a high volume court, though not quite as many as in the criminal area. County Court's got more in it than it did in crime in its original jurisdiction, lots of personal injury cases and various other cases in civil. And there you can see that the Supreme Court Trial Division does 5,500 cases in the civil area compared to about 100 in the criminal area. And that's because a lot of the commercial disputation cases in Victoria go to the Supreme Court Trial Division. And the Supreme Court of Appeal has 450 appeals in civil. Really just to show you that the Magistrates Court is a lower level, high volume, fast throughput court, and then things get narrowed down as they go into the more serious courts at the higher levels. Now, the last thing I want to talk to you about was a who's who in the legal system. You often hear about lawyers, you might hear about barristers, you might hear about solicitors, you probably hear about judges. You probably have a fair understanding of what judges do in the courts, and you may very well have a good understanding of what barristers and solicitors do, but it's a bit confusing even to people who work in the legal profession sometimes. It certainly isn't like it is on American television. So if I could just put that bit in. Judges obviously apply the law fairly, make decisions according to law, make sure a hearing's fair and so forth. Generally make decisions, although of course if there's a jury trial, it's the jury who decides whether a person's guilty or not guilty, not the judge. So that's what judges do. I think that's pretty straightforward. In Victoria, if you do a law degree and you do the requisite requirements after your law degree of some professional experience and perhaps a bit more study, then you can be admitted to practice as a barrister and solicitor of the Supreme Court of Victoria. So that means you're a lawyer and you're admitted to practice as a lawyer. Solicitors generally work in offices and do the paperwork and the preparation work, give advice to clients and help them with all sorts of things that are never going to get anywhere near a court, such as buying and selling property, etc. Those sorts of things are dealt with by solicitors. But solicitors are allowed to stand up in court and advocate for people. They can be barristers too. But if you want to hold yourself out as a specialist barrister, then you have to do the bar readers course and you have to sign the bar roll. So barristers, people who walk around generally work as barristers and belong to the Victorian bar, work as advocates in the courts for people, and they also work as specialists in various areas where they do opinion work. That is, for example, a solicitor will say to a client, that problem's too complicated for me, I'll have to get a barrister's opinion. So they send off a brief to the barrister, explain what the problem is, and the barrister writes an opinion about what should happen, what the course of action might be, what the best thing to do is. So there are judges, barristers, solicitors. So the barristers and solicitors are all lawyers. So judges, of course, are qualified lawyers as well. And then there are all sorts of other people that work in the courts. There are clerks of courts, there are associates, there are tipstaves, depending on which court you're in. And there's all of the back office work, the registry and the registrars. So there's lots of people involved in the legal system. Of course, the other people that you often might think of as operating in the legal system are the police. The police are a separate system from the courts. The police, of course, prosecute people for committing crimes and try and prevent crimes, but they are really a party in the law courts. That's the way they operate, and they prosecute matters in the Magistrates Court. In the County Court, the Office of Public Prosecutions does that. So that's some of the people who are involved in the legal system. Thank you very much for listening to all of this. I wish you good luck, and I hope you have a lot of fun studying legal studies. Good luck with everything. Thank you.